Court is calling 2023 CR 1121, State of Texas versus Javon Crockett. Can I have parties announced for the record for the state,
Raymond Solana,
for the defense?
Leslie Sahamovich for Mr. Crockett.
All right, and are you Mr. Crockett?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Javon Crockett who was placed on deferred adjudication in 2023 CR 1121 for the offense of assault, family choking, strangulation on June 6, 2023 for a period of 8 years?
Yes, ma'am.
State?
Moving forward with condition number 33. The first one, on or about the 8th day of August 2023 in Barron County, Texas, the defendant Javon Crockett failed to submit urinalysis test in violation of condition number 33.
How do you plead to that, true or not true?
True.
If you violate condition number 33 on or about the 14th day of August 2023 in Barron County, Texas, the defendant Javon Crockett failed to submit urinalysis test in violation of condition number 33.
How do you plead to that, true or not true?
True.
They will be waiving the remaining violations.
Any objection to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of conditions 33 and 33, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 33 and 33?
Yes, ma'am.
Court will find 33 and 33 true. Is there a proposed agreement?
There is, Judge, we ask the court grant the motion, revoke this community supervision, and sentence him to 5 years CPC. As part of the agreement, the state will be taken into consideration. Case number 2024 PF 16309 is updated by the.
Is that the proposed agreement?
That's.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Court will find 33 true, 33 true. The court will find you guilty, revoke. Taking consideration 2024 PF 1639. There's an affirmative finding of family violence. There's to be no contact with Kayla, Kayla, Verlander, Verlander. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel?
Thank you.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And of course, counsel, I gave your client credit for any time that he has been in custody.
Thank you, Your Honor.
All right, we can go off the record. Here's the thing. The complainant in this case wants nothing else to do with you. She doesn't know you. You don't know her. That relationship is over. If you insist that that relationship is not over, you're going to find yourself right back here and perhaps going to a prison for longer. You understand?
We've been finished, ma'am.
All right, make sure it stays that way.
Yes, ma'am.
And don't get involved with a relationship until you get an orchid and that orchid reblooms. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Judge?
I'm sorry,
Yes.
Judge, what was the sentence?
Oh, thank you so much. See? What did you all agree to for sentence? 5 years? Thank you, Vashawn. 5 years TDC.
Thank you, ma'am.
All right, good luck. Vashawn, he was gonna go to prison and people would say, we don't know what the sentence is. All right, did you review the document? I'm sorry, did you review the page entitled plea bargain?
Yes, ma'am.
And did you review it with your attorney and understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There is no fine. There is no application for deferred adjudication. The state recommends community supervision, and they're taking in consideration 2023 CR 6644. Did you understand that to be the plea?
There's 6 years probation.
No. So the way it works is both of you all agree, if you can, on what your punishment will be if you're unsuccessful.
Okay.
So what this means is if I follow this agreement and if at some point you violate your conditions of probation, The most I can sentence you to is 6 years in the prison.
Okay,
So did you understand that to be the plea?
I understand now. Yes, ma'am.
All right, defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
All right, and in this case, there is no affirmative finding of family violence, is there?
That's correct.
Okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your supervision be for a term of 6 years and there be no contact with Ruby Underwood and Diana Medina. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
The state of first state exhibit one involved attachments.
No objection to state one in attachment, Your Honor.
All right, and state, is the complainant aware of this case?
Yes, Judge.
All right, state, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Counsel, what is this case that's being taken in consideration? The 2023 case.
It's an assault, choking strangulation, Your Honor.
All right, and was there no contact order? In that case, I'm assuming there was.
I think there was no contact order in place on the 2023 case, Your Honor.
And is he on probation?
No, Your Honor.
Okay. Oh, that's the case that he withdrew and he decided not to plea on?
Yes, the 2023 case will be, yes, Your Honor.
Okay. No, I mean, because there was a previous waiver and consent to stipulations done in that case.
Right, so the lawyer that I substituted for was in a plea on that particular case, Your
Yes.
Honor. Yes.
Ah, okay.
And the plea was withdrawn.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just asking the court to follow the plea agreement, Judge.
All right, so why did you go over there? When they say you're not supposed to be over there, they know you're not supposed to be over there.
She had invited me over, the ex-girlfriend. Baby mom.
I'm sorry, who?
My baby mama, Ruby Underwood.
You mean the mother of your child?
Yeah.
You're saying that she invited you over?
Yes.
And is that her house that she invited you over to?
It's her mother's house.
All right. So people need to learn that you need to get permission from the person who owns that home. You understand? Now, is Child Protective Services involved at all because of the other case that is being taken in consideration?
No, Your Honor.
State, do you know if CPS is involved? All right. So have you seen your children at all or no?
Yes, the last I saw my son was Father's Day.
Are you employed?
Yes, ma'am.
What do you do?
I'm a welder.
How long have you been doing that?
Since 2014. I'm self-employed.
And how many children do you have?
I have 2 children.
And is it with Ruby Underwood?
One with Ruby Underwood, and I have a separate, I have a daughter, 7 years old.
All right, this is what the court is going to do. Court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with Ruby Underwood and Diana Medina. You'll have to have a third party involved to do child exchanges. Proof of employment within 30 days, no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. 200 hours of community service restitution. I'm gonna order parenting classes and anger management. Once those are completed, the community service hours are deemed satisfied. Field visits, one time per month for 3 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
What do you want?
All right, and I'll take in consideration 2023 CR 6644. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to start making better decisions. Otherwise, you're gonna be back here. Now, I put into place no contact order. Here's the thing, and your attorney will tell you, this is what usually ends up happening. People decide they want to get back together. And then they get back together, everything is fine. And then maybe somebody doesn't want to take out the trash, or there's an argument because somebody has a girlfriend, or somebody thinks somebody's cheating. Police get called, and then usually a person will come in here and they will say, but I didn't do anything, nothing happened. And you know what the question I'm going to be asking you? Why do you have contact with them anyway? Because I told you no contact. You understand?
Yes, ma'am.
All right. If you need anything, let your probation officer know. If you feel as though they're not addressing your issues, you can always come back to court. All right, good luck to you.
Thank you,
Thank
Judge.
you. Who's here on Brandon Pena? All right. So this was previously set for a hearing on July 31st, and he left and never returned.
That's my understanding, Judge.
All right.
I was also not the attorney at the time.
So first things first, is this going to end up being a contested?
We don't have an agreement right now. I mean, obviously, our goal is gonna be to try to work it out. But Mr. Pena has been very actively working services with CPS and being tested through them. And there's a lot of material I need through that apparatus to bring to court that I think would be helpful for the court's understanding. And so obviously, I'm gonna need some time to get that done. I just got hired over the weekend.
Okay. So how much time do y'all need for a contested? What date?
I'd ask for approximately 30 days, Judge.
Okay, I'm not gonna give you all 30 days. He's been gone since July of 2023.
Yes, Judge.
So. State,
Yes, Judge.
how long would it take you to have your witnesses?
Not long, Judge. It shouldn't be, if I believe correctly, shouldn't take that long.
All right, so the week of October 28th?
That should be more than enough time, Judge.
All right, Ms. Ferguson, if you'll put this down for October 31st. And I'll put it down as a contested. If it's not a contested, you all just let me know.
I understand, Judge.
All right, now the next thing, defense has filed a motion for a bond, is that correct?
That's correct, Judge.
All right, we're gonna go on the record. Court is calling 2020 CR 1209, State versus Brandon Rocky Pena. Could I have parties announced for the record for the state?
Yeah, U.S. Court for the State of Texas.
Okay.
Luis Martinez on behalf of Mr. Pena.
And are you Mr. Pena?
Yes, ma'am.
You're gonna have to speak up so the court will. All right. So defense, you're asking that a bond be set?
Yes, Your Honor.
All right, and he's entitled to one based upon the fact that he's on deferred adjudication. Have you all had a chance to confer on a bond amount?
Judge, we haven't had a chance to confer. I don't believe we're in agreement.
All right. Do you all want to confer on a bond amount?
Judge, we've conferred on it.
Oh,
And,
okay.
and so, so Mr. Pena's very much in need of getting out. He's involved in the CPS case, like I've told the court. He's been working services, he's been taking his classes. There is a final trial on the merits on Thursday. We're trying to get him available for that. I know that, I mean, obviously the hard for me to come here and say, Judge, don't worry about it, he'll be here, because he didn't show you that before. But I think the fact that he's been working through that system and staying clean and participating in that, and what CPS has asked him to do, and I've got,
But is he clean because he's in custody?
our contention is he'd be clean even if he wasn't in custody, Judge, and we've got a certificate from his parenting classes.
Any objection to the court
No.
meetings?
And so obviously he's clean right now, Judge. Obviously, he's in custody. What he contends to me is that even if you weren't in custody, he'd be clean because he's trying to stay in compliance with CPS. So to that end, Judge, I'm asking the court to set a bond. The last bond he had in this case was $15,000. I'd ask for something around that amount. The family doesn't have all the money in the world.
You want to call your client as a witness with regards to bond amount?
Sure.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense?
So Brandon, you guys know what, you understand how bonds work, right? You're paying 10% of whatever the bond premium is. Okay, so the judge were to set a bond, for example, the last one was $15,000. You'd have to pay approximately $1,500 to get out. You understand that? Yes. Okay. Now, do you, to the best of your knowledge, does your family have, let's say, $15,000 or $10,000 that they can pay for a bond?
Okay, I cannot hear you and the court reporter cannot hear
You
you.
have to speak up and speak clearly.
Oh, not that much, you don't have that much.
Okay, wait a second. I'm sorry, I didn't understand what you were saying. To the court reporter, did you understand what he said?
Got it, Judge.
Okay, repeat it for me, because I didn't hear.
Yeah, my family don't have enough money.
Okay, he said his family don't have much money.
That's correct.
Okay.
So in your opinion, I mean, obviously it would take a couple of weeks for them to scrape up enough money to bring me aboard on this case, right?
Yes, sir.
And so if your family had to come up with money, would they be able to come up with approximately $1,000? Would that be kind of pushing it?
Yeah, yes, sir.
When we have to speak up,
Yeah, yeah, come up with 1,000.
Okay, so you're asking the court to set,
I'm so sorry. Here's the thing. I cannot hear you. You're speaking very fast and all of your words are running together. And it's making it hard for me to hear. So, could you repeat your last question?
do you believe that your family can come up with about $1,000 to get you out?
Yes, sir, they can come up with 1,000.
Okay. Do you believe that they'd be able to come up with significantly more than that?
No, no more than that.
Okay, well, speak clearly, speak slowly.
Yeah, $1,000 they can probably come up with.
So are you asking this court to set a bond somewhere around $10,000 for you in this case?
Yes, sir.
Okay, you understand that you've been gone before, right?
Yes, sir.
Oh, you understand that's going to be taken into consideration when the bond is set.
Yes, sir.
But you have been staying clean, correct?
Yes, sir.
You have been staying out of trouble, correct?
Yes, sir.
There's no new offenses that are alleged.
No.
You've been working services through CPS,
Yes, sir.
and you very much need to be at that hearing on Thursday, correct?
Yes, sir.
So you're asking the court to take those factors into consideration?
Yes, sir.
Are you working right now? Well, where were you working before you got picked up?
Yeah, working with my brother, he owns his own business, cutting trees.
Okay, so you cut trees. But approximately how much do you make cutting trees, approximately?
Per day, like 100, 125.
So maybe 100 to 125 a day. How many days a week were you working?
5 days out of the week.
Okay. But how long have you been in custody now?
3 weeks.
And so for those 3 weeks, your family's had no income.
No,
And so there's not, $1,500 or $3,000 in a savings account somewhere. But any money that you made has been spent.
no,
Any money that you had made before has been spent by now, right?
or
As far as conditions, if the judge were to have you report weekly and test weekly, would you be able to do that?
yes, sir.
And once again, it's your contention that if the court were to test you, you'd be tested negative, right?
All right, any questions?
Yes, how many times have you gotten bond before where you later never showed up to court?
I was just one time.
So you previously have been given a bond and then you never showed up to your next court date. Is that correct?
Yes, sir.
Nothing from the state, Judge.
All right, and with regards to his CPS hearing that's upcoming, my understanding that they do have, if it's a jury trial, they will have them brought over, is that correct?
Judge, I don't know, I don't practice in CPS court. I know that you've got some experience with that, Judge.
Unless they changed, because if they're trying to terminate your parental rights, they have to have you brought over, or they may be doing it by Zoom. But my understanding is on the civil side, Zoom would have to be agreed to. Otherwise, they'll bring you over from the jail for your hearing. So it won't be a matter of you missing your hearing unless you waive appearance. All right. So how much are you asking for defense and a bond?
Judge, the last one was 15. The family, I think, could be able to hire a bondsman and, you know, somewhere in the $15,000, $20,000 range. If the bondsman will take 5% upfront, which they usually will. So that's what I'm asking the court to do, is to consider something in the $15,000 to $20,000 range, with weekly leeways and weekly reporting.
All right, state, what are you requesting?
Judge, state's asking for $40,000. There have been previous times where he's not reported after getting a bond. Again, that's been a recurring issue in this case. We also asked for GPS, partial lab work, and weekly reporting to make sure that he's staying on track.
All right, the court set your bond at $15,000, partial GPS, waive fees, and it's for employment only. And of course, I will put in for also all court settings.
Yes, Judge. No,
Is there anything else?
Judge, my concern is, sometimes even when we post bond, if there's a GPS hold, they don't get released until there's a GPS available for them.
Oh, there should be one.
That it's just been my experience, Judge, that can certainly be a holdup.
If there isn't, let the court know and we'll take care of it.
Okay.
All right.
Thank you so much.
All right, thank you. Court is calling 2024 CR 1637, State versus Brenda Rodriguez. Can I have parties announced for the record for the state?
Michael DeLeon for Ms. Rodriguez.
And are you Ms. Rodriguez? Counsel, have you received all of the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're reducing it to a Class A assault bodily injury case.
Any objection?
No objection, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor?
Yes, ma'am.
Range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bear County Jail
Yes,
and up
ma'am.
to a $4,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do believe she's legally competent and sane at the time of the offense.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault bodily injury. There's a $1,500 fine. State is silent on your application for deferred adjudication. State recommends community supervision. There's to be restitution, if any, and restitution, if any, to Angel, A-N-E-L, Yoselin, Y-O-S-E-L-I-N, Soto, Figueroa. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver appeal paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No such motions filed, and I would like to be heard on her application for deferred.
All right. Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours of community service restitution, and no contact with Angel, Yoselin, Soto, Figueroa. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, to the offense of assault bodily injury as a class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence?
State offers exhibit 1 and all attachments.
We reviewed that, Your Honor. We have no objection.
All right, did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are proceeding, I would like to be heard on deferred. briefly,
Yes.
Judge. Ms. Rodriguez is 38 years old. She works at Popeye. She makes $13 per hour, Judge. No priors in her adult history whatsoever. This was just an unfortunate incident that got out of control. She's taking responsibility for that. We're asking the court to, if there's a possibility of probating any of that fine. Additionally, the state's recommending 2 years probation. We would respectfully ask for 12 months to 18 months of deferred adjudication. Given the fact that, you know, she is entering this plea, and we believe that the whole burglary of habitation situation got blown out of proportion.
All right, so Ms. Rodriguez, why are you in a fight with the complainants?
It's, due to my son, but I didn't want to involve him.
That was what?
It was due to my son, and he's 13 years old. He was visiting my father that lived in the same apartment. It's like a duplex as a noun. And she verbally was assaulting like him, telling him stuff. He called me frightened. I was at work actually, because I used to work from home. I went to go pick him up. I did not know that that was gonna happen. When my son got into my vehicle, he was just shaking. He, you know, things like that. So it just kind of, my mother instinct just kind of kicked in and.
No,
I
I mean,
just
the
realized
mother
that.
instinct is like you pick up the phone and call the police.
Yeah. I just-
So did anybody hit him?
No, it was just like, I mean, just threatening that was it for him, but,
So how do you know them?
I know her since she was younger, but my sister lived with her. My sister, she had a CPS case and my sister was the one that was, living with her so she could have supervised visitation with her daughters, so that's how I got to know her.
All right, and who is Vivian Morales?
I don't know her. I think she was just there visiting. Anel, I don't even know who that is.
I'm sorry, Viviana Morales. All right, here's your choice. I can give you deferred adjudication. If I give you deferred adjudication, it's going to be for 2 years. Or I will give you probation for 1 year, but it'll be a conviction.
We'll take the deferred adjudication, Your Honor.
All right, the court will sentence you to 2 years deferred adjudication. There's a $1,500 fine that'll be probated, restitution if any, and no contact with Angel Yoslin Soto Figueroa. There's to be no contact with Viviana Morales. There's 150 hours community service restitution. That will be deemed satisfied once anger management is completed. Proof of employment within 30 days, no employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits, 1 time per month for 2 months. Probation, is there anything else? Is there anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Thanks for dressing appropriately for court.
Thank
I
you.
hope you look back on this and realize you should have done things
100%.
differently.
I'm not gonna, I have a grandson that I wanna visit in California, and because of this, I haven't been able to do that, so.
Okay.
Yeah, first and last time.
All right, but the grandson is not with your 13-year-old, right?
No, I have
Okay.
my oldest daughter, cause she's in the Navy, so she's stationed over
Oh.
there, so, yeah, my grandson is gonna turn a year, so I haven't seen.
Oh,
him.
you have to go over there and
Yes,
spoil
I
him.
do. So I'm
And
just
then
trying
you have to
get-
have your daughter say, you didn't allow us to do this, but then you can say, yeah, but I'm the grandmother.
Yes.
All right, good luck to you.
Thank you
Thank you,
so much.
Judge.
You're welcome.